Confidentiality in general means keeping something private to be entrusted with a secret. Confidentiality as a legal privilege arises from different sources of authority and is not automatic simply because a mediator and the parties agree to maintain the confidentiality. Often that is enough, but a specific legal privilege may require a little bit more. So let's look at some of the sources of authority for a mediator's duty, and in particular, the mediator's duty of confidentiality as imposed by the professional codes. There are two primary codes of professional ethics for mediators. The Model Standards of Conduct for Mediators, developed in 2005, prepared by the American Arbitration Association, the American Bar Association, and the Association for Conflict Resolution, and JAM's Mediator Ethics Guidelines. The professional codes of conduct impose a duty on the mediator to, among other things, keep the matters of the mediation private and not disclose them to others unless agreed to by the parties or required by law. And this is why the legal privilege can be important, because that creates a limitation on what the law requires with respect to the duty to disclose. But in most cases, the code imposes an affirmative duty on the mediator to keep things learned during the mediation confidential. Let's take a minute to define what a privileged communication is. That is a statement made between certain parties which the law protects from being revealed in another forum. It's created by laws, rules of court, and there can be exceptions to it. Parties should always consult with counsel to clarify what exceptions may exist in their particular situation. If there's an insurance company involved, there may be some particular exceptions, but that can vary from jurisdiction to jurisdiction. The purpose for a rule protecting certain communications is to encourage free and open exchange of information between the certain parties. We're all familiar with things like a doctor-patient privilege or a spousal privilege or the attorney-client privilege. If those parties aren't protected to be free in their communications, then there are potentially problems with those relationships. And of course, the same is true for that relationship between a mediator and the parties and other participants in the mediation. In order to effectuate settlement and build communication, the parties need to be able to be free in their speech, and if that results in their saying things which then could be used against them later in a court or an arbitration, it's going to have a chilling effect on the mediation, and that's why it's important that this privilege exist. One of the sources of authority that creates the privilege is a state statute. In Massachusetts, the Mediation Confidentiality Statute is Mass General Law, Chapter 233, Section 23C, and that imposes some limitations on when it applies. It only applies to mediations that are conducted by a mediator who has completed at least 30 hours of training, and deeper within the statute there are some definitions about what constitutes training. And the second condition, which also must be met, is where there's a written agreement to mediate or the mediator has been appointed by a court or other governmental body. If those two conditions aren't satisfied, then the statute does not apply and neither does the protection. Mass General Law, Chapter 233, Section 23C is a little bit different from some of the other state procedures. It has a twofold aspect. It creates the affirmative duty, similar to that found in the codes, that the mediator must keep matters confidential, but it also creates the protected privilege. The mediator cannot be compelled to testify as to the matters disclosed in the mediation. There may be rare exceptions, but they are rare. It's important to note that Massachusetts was one of the first states to implement such a statute, and it's also interesting that being so early in the game, they have this requirement for training. Some of the other states have adopted what's called the Uniform Mediation Act. It was developed in 2001 by the National Conference of Commissioners of Uniform State Laws. I believe it's been adopted in about 10 states, but it is not the law in Massachusetts. Mass General Law, Chapter 233 is our confidentiality statute here. The Uniform Mediation Act just creates the privilege, but it does not create that affirmative duty. And there's a link here on this slide if you want to look at it in more detail. Keep in mind that those are just 2 examples of state statutes. There are other sources that create the authority for a privilege. There are many federal statutes and the rules of state and federal courts as well. One other side note is that mediators may build into their mediation agreements that they make the parties sign before starting the work of trying to resolve the case. They might build in exceptions. You usually only see this in extremely extenuating circumstances. For instance, a mediator of a family dispute may build in an exception so that he or she can report child abuse. It's rare in construction, but I have heard of instances where an industry professional such as an architect or an engineer may want to freely be able to report public safety issues if such information comes out during the course of a mediation. So keep those points in mind.